This is Barry Zalma, Zalma on Insurance. I am an attorney who has retired from the practice of law, now spend my time as an insurance claims consultant, an insurance claims expert witness, as an author and producer of these videos. Today I'd like to talk about the California Fair Claims Settlement Practices Regulations and the reasons why they exist. In 1993, the state of California determined that the insurance industry needed to be regulated to stop insurers from treating the people insured badly and without good faith. It created a set of regulations called the California Fair Claims Settlement Practices Regulations to enforce the mandate created by the California Fair Claims Settlement Practices Statute, which is California Insurance Code Section 790.03 (H), in response to the direction of the California Supreme Court, which was issued in a case called Moradi-Shalal versus Fireman's Fund in 1988. In so doing, the California Department of Insurance attempted to micromanage the business of insurance claims and create a method to punish those insurers who failed to comply with the regulations, but who had lost their ability to sue individually for breach of the statute. Some of the regulations asserted what had always been recognized by the insurance industry as good faith and proper claims handling. Others imposed draconian mandates on what and when to do everything in the claims process. The regulations also provided a guide to insureds, public insurance adjusters, and policyholders' lawyers to assert any violation of the regulations to be evidence of an insurer's breach of the implied covenant of good faith and fair dealing. All insurers doing business in California must comply with the requirements of the regulations or face the ire of and attempts at financial punishment from the California Department of Insurance. That punishment is now questionable and limited because some courageous insurers fought the California Department of Insurance and succeeded before an administrative law judge who limited the state's right to punish insurers. Regardless of difficulties in assessing punishment, the state of California requires all who are involved in the claims process, even if only tangentially, to be trained with regard to claims handling and compliance with the regulations, and attest to completion of such training under oath. To avoid the annual training, the claims person can submit a sworn document that avers that he or she has read and understood the regulations. It is necessary, therefore, that insurance personnel who are engaged in any way in the presentation, processing, or negotiation of insurance claims in California must be familiar with the regulations. Counsel for insurers and policyholders should also be familiar with the regulations since they set a minimum standard for claims handling in the state. Since the California regulations are probably the most stringent in the United States, and since many other states have adopted fair claim settlement practices regulations based on a model created by the National Association of Insurance Commissioners, it is appropriate to study the California regulations, and if they are complied with, the regulations in other states will also be complied with. The insurer's lawyer will need to know and establish that the insurer fulfilled the requirements of the regulations, since that fulfillment will show to a trier of fact that the insurer conducted itself by doing everything required of the minimum standards required by the regulations. A knowledge of the regulations can assist the lawyer in evaluating the exposure faced by an insurer. Similarly, the lawyer representing a policyholder client needs complete knowledge of the regulations to use them to prove that the insurer failed to fulfill the minimum standards set by the regulations. This is a bare minimum of any proof required in the filing of a breach of contract or bad faith suit against an insurer for failing to pay a claim. Compliance with the regulations is important to the evaluation of a claim for breach of the covenant of good faith and fair dealing and evaluation of a claim of damages resulting from the tort of bad faith. Knowledge of the requirements of the regulations are important to everyone involved in the business of insurance, whether as an insurance adjuster, insurance claims manager, other claims management, public insurance adjuster, policyholder, defense lawyer, insurance coverage lawyer, policyholder's lawyer, and an insurance agent or broker. The Fair Claims Practices Regulations enacted in 1993, several years after being instructed by the state Supreme Court to do so in the Moradi-Shalal decision, because that court concluded, quote, neither Section 790.03 nor Section 790.09 was intended to create a private civil cause of action against an insurer that commits one of the various acts listed in Section 790.03, Subdivision H. The Supreme Court concluded that enforcement of that statute was the obligation of the California Department of Insurance and no one else. The California Department of Insurance, 5 years after receiving instruction from the Supreme Court, issued the first version of the regulations and then modified those regulations in 1996, 1997, 2004, 2007, 2009, and 2012. The 1997 changes named the regulations the California Fair Claims Settlement Practices Regulations, which name remains today. The regulations imposed on all insurance personnel a detailed laundry list of actions that the California Department of Insurance considered wrongful or in violation of the Fair Claims Practices Act, California Insurance Code, Section 790.03. The regulations impose on all insurance claims personnel the requirement that they read and understand the regulations or attend an annual training program no later than September 1 of each year. Insurers are compelled to ascertain that every employee involved in any way in the claims process is trained about the regulations or has submitted a sworn statement that he or she has read and understands the regulation. The regulations even require that the insurance claims managing executive attest under oath that each employee has been trained with regard to and or understands the regulations. This requirement must be complied with in order to avoid the possibility of administrative penalties upon the insurer or prosecution of the officer for perjury. My book, California Fair Claims Settlement Practices Regulations, and its appendices can be used by insurers, the insurance claims person, and their trainers, educators, or lawyers to effect compliance with the regulations by 1. Providing training annually for all claims personnel, or 2. Assisting the claims personnel in their obligation to read and understand the regulations. The book can also be used by policyholders, public insurance adjusters, and lawyers representing policyholders to assist their clients in presenting and resolving claims made to insurers, whether by negotiation or litigation. The appendices include an outline for use by insurance claims personnel in presenting a training seminar to insurance claims personnel. Reading the book alone should give the reader sufficient information to declare under penalty of perjury that he or she has read and understands the regulations if a training class is unavailable or inconvenient. In addition, the insurer who presents the training materials should be able to ascertain that each of the insurer's employees who need to be trained were adequately trained. Insurers must understand that every claims employee must be trained annually in accordance with the requirements of the regulations, no later than September 1 of each calendar year, and insurers must be ready to prove to the California Department of Insurance compliance with that requirement. Failure to provide evidence of compliance with the regulations can cause the California Department of Insurance to assess major fines against the insurer. Those found in violation can be fined up to $55,000 for each violation and may even lose their certificate of authority to do business in California. For example, an insurer with 100 employees who have not been trained could probably face a fine of $1 million or more. This video was adapted from my book, California Fair Claims Settlement Practices Regulations, available from Amazon.com as both a Kindle book and as a paperback. If you found this video to be useful to you or your colleagues, please send them the URL so that they can also view the video. And please subscribe to my blog so that you can be advised of new and different videos and different summaries of insurance cases, which I post almost every single working day. Thank you again for your attention.